So we're going to jump back into Lisa Allen's testimony to the Post Office Horizon IT inquiry, where she's discussing with counsel to the inquiry, Emma Price, about her legal duties and her disclosure duties and whether she understood the role of a disclosure officer, referring back to what she's put in the statement. Let's jump into the inquiry.
Could we have on screen, please, paragraph 34 of Ms. Allen's statement? It is page 11. At paragraph 34, you say, "We adhered to PACE 1984, Criminal Procedure and Investigations Act 1996, Human Rights Act 2000, Proceeds of Crime Act 2002, Data Protection Act 1998. And you go on at paragraph 35 to say, there were also a number of RMG policies within our databases that we adhered to. The databases you refer to here, were they Royal Mail Group databases or a post office database or databases?
They was all held by Royal Mail Group.
And how would an investigator access this database or databases?
I believe we had a corporate security database on the intranet, so everything was listed on there, the communications, the policies, etc.
The legislation you refer to at paragraph 34, where would an investigator find copies of that legislation if they wish to refer to any of the legislation referred to?
On the corporate security database, we were provided with PACE books and the CPIA books, but the majority of the stuff we could find was on the Royal Mail Group corporate security database.
So she seems fairly well aware of the legislation that affected her role. She does list more legislation than I think we've seen most witnesses list. I think it's fair to say, because most have mentioned the Police and Criminal Evidence Act 1984 and the Proceeds of Crime Act 2002, but she goes on to mention things to do with human rights and data protection as well, so more comprehensive. And she does seem to remember where these could be found and that copies were available to them.
Could we have on screen, please, paragraph 22 of Ms. Allen's statement? That is page 5. And under the heading of disclosure in criminal or civil proceedings, you say, "In all cases where I was officer in the case, I was also the disclosure officer. My role as the disclosure officer was to retain, record and reveal any material that may assist the defence or undermine the prosecution case."
That's an interesting part of a witness statement there, because actually most investigators, when they're asked about who the disclosure officer was, never mind wanting to admit whether they were it or not, she's clearly saying, when I was the officer in the case, the officer in charge essentially, I was the disclosure officer and I knew that these were my duties. So it's quite refreshing to see that clarity in duties.
I was responsible for completing the disclosure schedules and conducting all reasonable lines of inquiry. At the time you were an investigator with the Post Office, did you understand that the disclosure officer role was a distinct role which you held over and above your role as an investigator?
I knew I was signing the documentation as the disclosure officer because that's what it says on the form. Whether or not I properly understood, I'm not 100% sure.
Did you understand that holding that role imposed upon you additional and distinct duties?
I knew I had to obviously record, retain and reveal information, and I had a duty to do that, and it was an ongoing duty. That was my understanding probably at that time.
At the point of submitting your report to legal services for advice on charge and prosecution, what documentation would you provide to the legal team?
So when
you produced your legal report for the criminal law team, having done your initial investigation, and we'll come to an example of one of those reports later. At that stage, what documentation would you provide to the legal team apart from that report itself?
Tape summary, any witness statements that have been taken, any evidence from those witness statements, the disclosure documents, MPA forms, antecedents, I believe.
When you say disclosure documents, do you mean that disclosure schedules were provided
Yes.
at that stage?
Yeah. Yes. I think, they would have been put in the jacket at that time.
Was it at that stage as opposed to at the point of doing the committal bundle?
May have been at the committal, actually. I think it was when I would have done the committal bundle, actually.
You refer at paragraph 22 of your statement to conducting all reasonable lines of inquiry. You also address lines of inquiry at paragraph 55 of your statement. Could we have that on screen, please? It's page 17. You say at 55, an investigator should take steps to make all reasonable lines of inquiries under CPIA that points to or away from the suspect. The question you were responding to here relates to instructions, guidance, and/or training on the duty to investigate a case fully. You don't, in your answer there, identify any instructions, guidance, or training. When you were a post office investigator, were you ever given any instruction, guidance, or training about what following a line of inquiry, pointing away from a suspect, might mean in practice?
I don't recall any specific training given to it, but I can give an example of a case where I think the subpostmistress may have been arrested in relation to a green gyro fraud. Having interviewed her and her giving the explanation, I went away and made some inquiries from what she'd said in interview and identified that she'd been actually targeted by an organised crime group. She was subsequently reinstated, but obviously given further training on how to identify manipulated green gyro checks. So, yes, I think we did, I did investigate to the best of my ability.
To be fair, it does sound like, in contrast to many other witnesses, that actually what she's saying is, well, to the best of my ability, to use her own words, she has actually investigated lines of inquiry which point away from the suspect. That example there, it's easy to say, well, the fraud's happened on your watch. These are fraudulent documents that you've been provided, but they didn't really know that at the time. All they knew that was that it didn't match up by the sounds of things. And she's dug a bit further and realised that she herself, the subpostmistress, has been a victim of a crime, and that's created then the discrepancy, presumably, through the production of false gyro checks, which they're talking about there. Which were then cashed, so have subsequently led to a loss for the post office. So it sounds like in that case there wouldn't necessarily be no paper documentation to back up what she was saying, but there would be some evidence, as in these are the checks that were presented to me and that I've cashed.
My question related to instructions, guidance, and training. You've given an example of what you did in practice, but just going back to the question, you don't recall being given any instruction, guidance, or training on that?
I don't know.
Would you accept that fully investigating a suspected theft required an investigator to be satisfied that an apparent shortfall represented an actual financial loss to the post office?
Yes.
When you were an investigator, were you aware that the obligation to pursue lines of inquiry pointing away from a suspect extended to material in the hands of a third party, for example, Fujitsu?
Yes, I think so.
Could we have on screen, please, page 21 of Ms. Allen's statement? In response to a question about whether ARQ data was requested from Fujitsu, if we can scroll down a little further, please. So paragraph 74 is your response to a question about whether ARQ data was requested from Fujitsu as a matter of course in cases where sub-postmasters were attributing a shortfall to problems with Horizon. And you say, in response, I cannot recall if it was requested as a matter of course. Exploring that a bit further, please, do you accept, having seen the papers which have been provided to you by the inquiry, that you were involved in a number of cases where sub-postmasters were attributing shortfalls to problems with the Horizon system?
Yes.
In such cases, would you accept that it was a reasonable line of inquiry to seek more detailed audit data from Fujitsu to explore whether further data might support what the sub-postmaster was saying?
Yes.
Going over the page, please, to paragraph 75, when you were asked whether ARQ data obtained from Fujitsu was provided to a sub-postmaster as a matter of course, you say ARQ data obtained was not provided as a matter of course, but was retained for providing to the defence upon request. Taking this in stages, would any ARQ data which had been obtained as part of the initial investigation be provided to the criminal law team at the point that they were advising on charge and prosecution?
I don't know. Sometimes maybe, but not all the time. I wouldn't have thought.
Why not in cases where it wasn't?
Maybe it wasn't obtained at that time.
But where it had been obtained by an investigator,
yeah.
Why would it not have been provided to the criminal law team at the point they were advising on charging and prosecution?
I don't know.
And that does seem to be a bit of a hole in the process there, because you should just hand over everything, surely. I mean, I accept that it might not have been the post office's process and that might be the process that's wrong, and therefore not her implementation of said process. However, surely before any decisions being made, it sounds like the investigator reports, which we've heard about before, kind of went off and said, this is my view on the data, but then providing all the data would allow, theoretically, the criminal law team to make the best judgment, not only on the prospects of the case, but also whether they think they've got the right person and whether a crime has actually been committed, if they provided all the data as kind of appendices to these reports that are passed to them for a charging decision.
On the question of what was provided to the criminal law team, we've touched on whether disclosure schedules themselves were provided at the point of charge and prosecution. And I think you were saying it may well have been at the committal bundle stage. But in terms of material that you had collected in the course of your investigation, quite apart from any ARQ data, how much of the material were you providing to the criminal law team? Was it everything? Was it select documents?
It was probably documents that had been potentially exhibited within the statements, or documents that were going to be relied upon if a prosecution was authorised